your matter. I'm going to read the judgment. After that, then I will call your case. You are welcome, counsel. Yes, this is, you call the case, the one for judgment.
Suit number NICN YL02 2016 between Mandy Land and First City Monument Bank Limited.
Yes, any appearance? Any appearance? This is the judgment of the court. This matter is for judgment. The claimant, by an offer of appointment dated 7th of September 2006, joined the services of the defendant as a pioneer manager of the Neola branch of the defendant. The claimant, by the letter dated 5th day of May 2009, had his appointment confirmed by the defendant. The claimant was on the 5th day of October 2011 rewarded with a long service award. While the claimant was in service, the defendant advertised shares loan opportunities to her staff, to which the claimant applied and paid for 33,333 units of shares. The payment of the shares was done through deductions of the sum of 191,083 naira 54 kobo from the claimant's account with the dependent. The dependent failed to refund or allocate the shares despite the deductions of the amount. The dependent also made an authorized deductions of the sum of money amounting to the tune of 1,693,432 naira 35 kobo. Okay. From offset bad loans approved and granted by the defendant to his customers. Following the restructuring of the defendant, the claimant was advised to resign his appointment. The claimant was paid by the defendant the sum of 1,388,029 naira 50 kobo as terminal benefits, and after meritoriously serving the defendant for more than 8 years as a branch manager. The defendant failed to pay and deliberately excluded the sum of 783,278 naira 85 kobo. His outstanding monetized leave allowances as at December 2009. The claimant immediately registered his dissatisfaction and protest against the terminal benefit with the defendants through her Human Resource Department office in charge of Northern Region in person of Moyoshere Thomas via an email dated Friday, July 25, 2014. The claimant also caused his solicitors, Ms. Olu Adebambo and Associate, to write to the defendant demanding the immediate payment of the actual terminal benefit and sundry entitlement as contained in the complaint. That despite the solicitor's letters of demand, the defendant was adamant and refused to pay the claimant. The claimant also led a complaint against the defendant as the Public Complaint Commission Yola in September 2014, and the Honorable Commissioner, Public Complaint Commission Yola, wrote to the defendant, and same was ignored by the defendant. This suit was commenced by the defendant via a general form of complaint dated and filed on the 19th day of February 2016 to seek for payment of his terminal benefits and other entitlements. The claimant, with the leave of court, amended his complaint and his supporting processes dated and filed on the 15th day of January 2018. The claimant's claim against the defendant are as follows. A, the sum of 20,320,066 naira 59 kobo, being the terminal benefits and other entitlements of the claimant. Upon exit from the employment of the defendant, the B, 10% per annum commencing from February 2016 till judgment, and 10% interest from judgment till final liquidation. C, the sum of 2 million naira being legal expenses incurred by the claimant to recover the above stated amount. The cost of this suit. Upon being served with the processes commencing this suit, the defendant filed a statement of defense which was subsequently amended with the leave of court granted on the 15th day of May 2019. The claimant testified in proof of his case as CW1 after identifying his witness statement on oath of 15th day of January 2018, adopted same as his evidence in this case. CW1 also tendered documents which were admitted in evidence and marked as exhibit CW1A to CW1G. CW1A was cross-examined by the counsel for the claimant thereafter he was discharged. The defendant called one Ademola Adeyemi, a senior officer with the defendant, who testified as DW1 in proof of the defense put forward by the defendant before the court. DW1, after identifying his witness statement on oath on 7th day of May 2018, adopted same as his evidence in this case. Exhibit DW1E was tendered through this witness by counsel for the claimant under cross-examination. DW1 also tendered in evidence other documents which were admitted in evidence and marked as exhibit DW1A to DW1D. At the end of the evidence, counsel for the claimant, and thereafter he was discharged. The submissions of the defendant formulated a single issue for determination. The argument of counsel has been captured. I shall skip reading the argument. Likewise, the claimant formulated a single issue for resolution. It has also been captured in the body of the judgment, and all the argument canvassed therein. I go straight to the decision of the court. I have carefully considered the processes filed in this suit, the evidence led by parties, final written addresses, and oral submissions of counsel for both parties. The claimant and the defendant each formulated a single issue for determination. The issues formulated by the counsel for the parties are the same, with slight variation in the word used. The issue for determination posed by the parties is whether the claimant has, by evidence adduced before the court, proved entitlement to any of the reliefs being sought. I shall start by resolving the preliminary issue raised by the counsel for the defendant in his final written address, which borders on the admissibility or propriety of eliciting evidence under cross-examination through the use of unadopted witness statement on oath. According to counsel for the defendant, it is wrong for counsel to cross-examine witness with a statement on oath that has not been adopted before the court, as it has not become evidence. A statement on oath filed and not adopted is useless piece of paper which is not before the court, and the court cannot rely on it for any purpose. Counsel submitted that oral evidence elicited based on the unadopted statement on oath is inadmissible and should be expunged from the record of the court. Counsel maintained that for purposes of cross-examination, a witness can only be cross-examined to adopt witness statement on the adopted witness statement on oath. In support of the submission, counsel relied on the case of Idris versus Action Congress and also the case of Okapo versus Okpala. The counsel for the claimant in response submitted that the witness statement on oath is a document in the case file, and the court has the right to look at it, and the witness can be cross-examined on the document since it is before the court. I agree with counsel for the defendant that before witness statement on oath become evidence before the court, the witness statement must have been adopted by the witness himself before the court after the witness had been sworn in to testify in the case. The witness statement that was not adopted by DW1 is not evidence before this court in the real sense of it. However, counsel for the claimant has argued that The witness statement of oath is a document that is in the case file, and the court has the right to look at it, to examine it as it is in the record of the court. So the witness statement of oath is document before the court, and the court can on its own look at the document in its docket. For the document to be properly used, it must be a document that is free from any defect. It must be remembered that this court on the 15th day of May 2019 granted the defendant leave to amend its statement of defense and deemed the defendant's statement of defense and its accompanying processes filed on the 7th day of May 2018 as properly filed and served, with the order of the court granting leave to the defendant to amend its processes. The previous statement of defense and its accompanying processes have vacated the record of the court, as they have been replaced by the processes filed on the 7th day of May 2018 by the defendant from the claimant's account and the amended process by law dates back to the date of the initial process. Therefore, for any evidence to have evidential value based on statement on oath must be in respect of the claim, must be in respect of the statement on oath that is properly before the court. This means that the evidence elicited on the statement on oath that has been replaced as a result of amendment cannot have any evidential value. In the circumstances, I hereby discountenance the evidence elicited under cross-examination based on the witness statement on oath that has been amended. Coming to the main issue for resolution, it is settled that the reliefs are circumscribed by the relief sought, and the claimant's duty is to adduce evidence that will establish his case, and for the defendant to adduce evidence in proof of the defense. See the case of RTB versus Capital Metal Nigeria Limited. It is also an elementary principle of law that in determining claim of a party and the issues of contentions, the parties pleading as a whole must be considered. As the relief must be predicted upon the relevant pleaded facts giving rise to the claim. The claim or relief cannot exist in vacuum, but must be derivable from the facts that donate the right to claim the reliefs. It is thus settled law that reliefs claim in a case must relate to or arise from or be based on facts set out in the parties pleaded, as the pleaded facts being the foundation from which the reliefs must be built or pegged, without which foundation the reliefs would have no leg to stand or no structure to be pegged upon. Any relief claim that does not find its root from the pleaded fact in the parties' pleadings cannot stand in the law. See the case of Amusun versus INEC. Therefore, it is the fact pleaded in the statement of claim that shows entitlement to the relief's claim therein. So unless there are facts pleaded in the statement of claim showing entitlement to the relief, claims therein, the claim therein will fail on the pleading and does not qualify for trial. This means court of law hardly grant orders not sought or orders contrary to the relief sought, as they are not donors of charity, and as parties are bound by the relief sought in their pleadings. See the case of Kalio versus Kalio Supra. See also Union Beverages Limited versus Olabi. See also the case of Liman versus Mohammed. See also Okolo versus UBN. See also Umagokwe versus Ola Okadibo, and host of other cases cited therein. In the decisions of the Supreme Court in Ishola versus UBN Limited 2005 6 Nigerian Criminal Report Part 922, page 422 and 438, if Calgo JSC as he was held that a relief sought by a party to suit does not constitute part of the facts in the pleading, and it cannot be granted unless there are facts in the party's pleading in support of it, upon which evidence can be called. It is clear to me from the pleadings and evidence adduced the reliefs being sought by the claimant in this suit emanated from the alleged unauthorized deductions made by the defendant from the claimant's account for repayment of loan for purchase of shares and to offset the bad loan or non-performing loan granted to the customers of the defendant with the branch of the defendant where the claimant was then serving as manager. There are also claims bordering on omission to include monetized annual leave allowances of the claimant, deductions of unremitted allowances and allowances. There is also claim or long service allowances and balance of 10-month entitlement. In civil action cases are decided on the balance of probabilities or what is sometimes referred to as preponderance of evidence by placing the two sets of admissible evidence and admitted evidence on imaginary scale of justice to see which side outweigh the other, not by the quantity but by the quality or probative value of the testimony of the witnesses. See the case of Pat Benhu versus Arobadi and others. See also Mogaji versus Odopin. There are 4 reliefs being sought by the claimant in this suit. Relief A is for the sum of 20,320,066 naira 59 kobo, being terminal benefits and other entitlements of the claimant upon his exit from the employment of the defendant. This is the main reliefs in the claim of the claimant. The other 3 reliefs are ancillary reliefs dependent on the grant or refusal of the main reliefs. As can be seen, the main relief is a monetary claim bordering on terminal benefit and other entitlements. This means the claim is for special damages. It is certain law that claim for special damages must be pleaded and particularized so that the defendant will know what is to meet. See the case of some of Bottling Company PLC versus Augusto, where it was held that claims for gratuity, pension, housing fund, salary are all special damages and must be strictly proved. See the case of NNPC versus Kilipo Nigeria Limited. The claimant's claim in the instant case is for 20 million, being for the terminal benefit and other entitlement. For the claimant to succeed, the burden is on the claimant who claims monetary sum to prove not only entitlement of the sum, but how she comes about the quantum of the sum being claimed. And proof of entitlement is often by reference to an instrument or document that grant it. See the case of Mohammed Dungus and others versus ENL Consortium Limited. Note the oral testimony of the claimant, except if corroborated by some other credible evidence. In fact, the case of Joseph Akinola and others versus La Pardes Men Wafco Nigeria Limited has specifically cautioned against the reliance on oral evidence in proof of special damages. On the component of the release fee sought can be seen in paragraph 10, 11, and 12 of the amended statement of fact and paragraph 10, 11, and 12 of the witness statement on oath. The claimants about that through a share purchase loan for staff, he was allocated 33,333 shares of the defendant, to which a deduction for payment was made to his account, with the defendant amounting to the sum of 191,083 naira 54 kobo. The deduction were made from January 2009. The response of the defendant is contained in paragraphs 4, 5, 6, and 7, and 9, F and G of the amended statement of defense, and paragraph 6, 7, 8, and 9 of DW1 witness statement on oath. It was stated that due to poor performance of stock market and fall in defendant stock prices below the offer loan repayment did not commence then. Staff were only interest portion monthly, while the principal was left, and that the management of the defendant that payment of 50% of the payers the rest. However, upon exit, staff will still pay down the outstanding loan while the allotted shares are released. The claimant never opted for to pay down, which would have enabled the dependent to release the said shares. The dependent has argued that the claimant has failed to wholly prove his case against the dependent required by Section 136 of the Evidence Act. Houses submitted under cross-examination, the claimant admitted taking some loan from the dependent to purchase shares of the dependent, and some of the deductions being complained of were actually made toward the repayment of the loan, and the claimant admitted that he has not paid the loan collected for the shares. For the claimant, it was argued that the dependent has not denied or challenged the claims of the claimant. Counsel refers to paragraph 6, 7, and 8 of the witness statement on oath of DW1, which counsel submitted amount to admission of the claim regarding shares. Counsel also submitted DW1, admitted that deductions for shares were made by the defendant as shown in Exhibit CW18. I have considered the evidence and argument of counsel regarding the 33,333 shares allocated to the claimant, which is a sum of 191,083 naira 54 kobo, was deducted from the account of the claimant. As per Exhibit CW1H, the same with Exhibit DW1D tendered by the defendant. I note that none of the parties has told this court the value of the shares that was allocated to the claimant by the defendant, or the amount that was advanced as loan to the claimant. The claimant insisted that he has paid for the shares, therefore he is entitled to the certificate. The defendant refused to issue to him and failed to refund his money. The defendant has tendered Exhibit DWG, which is the claimant's application for the loan to purchase the shares in contention. In this case, I note, though the court document is not so legible without straining one's eyes, I note that the amount applied for the shares in the sum of 466,662 naira from the amount applied for the 33,333 shares. It will be right to say that the claimant has not wholly paid for the shares. From this evidence, if the sum of 193,083 naira 54 kobo is deducted from the sum of 466,662, there will be a balance of 275,575 with 46 unpaid balance, which the claimant has not paid to the payment of the said shares as allocated to him. This also excludes the interest to be charged as agreed by the parties. However, from Exhibit CW1H and DW1D, it is clear that the claimant has made some payment a rest of the shares. He is therefore entitled to have certificate for the number of shares he has paid for, or refund of the money which has been deducted for the said shares. Another component that made up of the reliefs is the claim for unauthorized deduction amounting to the sum of 1,693,432 naira 35 kobo to offset bad loans approved and granted by the defendant to its customers. The defendant response was that though the deductions were made in respect of delinquent customer, the deductions were refunded into the claimant's account. On this, reliance was placed on Exhibit DW1D, the statement of account of the claimant with the defendant. The claimant's abandonment regarding the unauthorized deduction to offset bad loan to customers of the defendant is as contained in paragraph 12, 13, and 14 of the statement of facts, and paragraph 13, 14, and 15 of the witness statement on oath of the claimant. In proof of this claimant refers to Exhibit CW1H, it is submitted that the defendant admits this unauthorized deduction in paragraph 11I of the witness statement on oath. It is clear to me that from paragraph 9A of the amended statement of defense, which is the response of the defendant to the claim for unauthorized deduction, clearly implies that the claimant's abandonment has been admitted by the defendant. Apparent abasement evasiveness of the defendant did not unequivocally deny the deductions, but only claims that the deductions were refunded, but DW1 could not pinpoint from Exhibit CW1H the exhibit that the refund was said to have been deducted, to have been made. The law is that an evasive bogus or general denial, a mere denial of a detailed factual situation without attacking the veracity of the details. Please, counsel should not allow their phone to be ringing. Please. Counsel should not allow their phone to be ringing. Please, the administrator should mute all the participants.
Thank you, my lord.
Administrator, please mute all the participants. The law is that an evasive bogus or general or mere denial of detailed factual situation without attacking veracity of the details, it reverts that dependent denies a named paragraph of the statement of claim, but shall at the trial require plaintiff's strict proof of abandonment contained therein. All do not amount to denial for the purposes of raising issue for trial. If anything, they all amount to admission. See the case of Akande versus Adisa. See also El Tijani versus Saidu. See Jacobson Engineering Limited versus UBA Limited, and host of other cases that were referred to. So by these rules of pleadings, the defendant evasive denial must be read to be an admission that it must that made unauthorized deduction from the claimant's account in respect of a delinquent customer. I so hold. Therefore, claimant is entitled to refund of the unauthorized deduction. The next item that is part of the release in payment of monetized annual leave in the sum of 783,278 naira 85 kobo. The response of the defendant was that claimant was advised of a monetized annual leave amounting to the sum of 783,278 naira 85 kobo. Same have been and same has been paid along with the exit entitlement. The law is that he who asserts the positive has the burden of proof. The dependent, having asserted paying the claimant his monetized annual leave, has the burden of proof that the said amount has been paid along with the claimant's exit entitlement. The defendant has not adduced evidence to establish the claim that the said monetized entitlement has been paid along with the end of service entitlement. This means that the defendant has not discharged the burden of proof on him. However, by paragraph 4.05 of the final written address of the defendant, counsel for the defendant considered that DW1 during cross-examination has admitted the claim of the claimant on monetized annual leave. This means that the sum of 783,278.85 kobo has been the claim has been established by the claimant, same having been admitted by the defendant. As it is clear from the pleading and evidence of the defendant, coupled with the final written address of the defendant that admitted the claim of the claimant on monetized annual leave, An admission that is clear and unequivocal, like in this case, is binding on the maker of such, and such maker cannot be hard to change same subsequently at a later stage of the suit based on new or fresh case. Therefore, facts admitted by a party in proceeding need not to be proved, as proof presupposes disputed fact. Consequently, where facts are not in dispute, the parties have no joint issues, which will require any proof by evidence. See the case of Akibu versus Odutan. See also Igwe versus ACB. See also Gabari versus Ilori. See also Supanu versus Ani Mashau, and a host of other cases cited therein. Courts are enjoined to act on admission, requiring no further proof therein. See Atanda versus Ilyasu. See Atanda versus Oliasu Pa Ogumbi JSC Ashiwa Danwa. The claimant has, by paragraph 17 and 18 of the amended statement, about that his pro rata entitlement for 10 months of 8th year in service is the sum of 533,333 naira 33 kobo. However, there is no any other evidence apart from the pleaded evidence that support this claim, as it is tried that claim for special damages must be strictly proved. The claimant has failed to do so. See the case of 7-Up Bottling Company versus Augustus. The burden is on the claimant who claim monetary sums to prove not only entitlement of the sum, but how she comes by the quantum of the sum. And proof of entitlement is obtained by reference to an instrument or document that grants the relief. Not oral testimony of the claimant, except if corroborated by other credible evidence. Court are cautious in relying on oral testimony as proof of such entitlement. See the case of Joseph Akinola versus Lafarge's men. The claimant having not prove how he came about this claim, he has failed in his duty of proof imposed on him by the law. The claimant has not also shown how he arrived at the amount being claimed for the 10th month for 10 months of his 8th year. The component of the item of claim has not been stated. On the claim for redundancy, there is no dispute between the parties on the exit of the claimant from the service of the defendant. There is consensus between the parties that the claimant tendered his letter of resignation because he was advised by the claimant to resign. This clearly shows that claimant's exit was based on advice by the defendant. Then the question to be resolved is, can this type of resignation amount to redundancy? Redundancy is usually provided for in the conditions of service. However, in the absence of condition of service, resort will be made to look at the level of where provisions were made in section 20 regarding redundancy. Redundancy is service. It has been heard on variously by the court that redundancy is service is a mode of removing an employee from service when his post is declared redundant by his employer. It is therefore not a voluntary retirement, nor is it a dismissal from service. It is also not voluntary or forced resignation, nor is it a termination of appointment. Rather, it is unique procedure whereby the employer employee is quietly and locally relieved of his appointment. As such, the conditions applicable for redundancy are quite distinct from those applicable to retirement and other modes of relieving an employee from active service, such as termination, compulsory resignation, or dismissal. Consequently, as a general rule, the declaration of redundancy does not carry along with it any other benefit except those benefits enumerated in terms of the contract to be payable to an employee declared redundant where applicable. See the case of Pan Limited versus OJ. See also the case of Adibu versus Mobil Oil. Usually, the conditions on which an employee may be declared redundant are found on its term and condition of service, but in the collective agreement between the employer and the employee. But unfortunately, the claimant did not, the dependent did not show, the claimant did not show or prove that collective agreement was part of his contract of service to justify his claim thereof. See the case of SPDC versus Nwauka. It is clear that the redundancy in employment is caused by an excess of manpower. Redundancy therefore arises where the termination of appointment is part of the reduction in the workforce. It is therefore a mode of removing an employee from service wherein his post is declared redundant by his employer. It is unique procedure whereby an employee is quietly and lawfully removed from his office or from his employment. In the case at hand, the claimant resigns through because of advice to resign as a result of restructuring of the claimant, restructuring of the defendant. This clearly shows that the claimant has not proved that he was affected by redundancy or there was having found the claimant has not. In view of the foregoing, it is clear to me that the defendant has not made a case for redundancy to entitle him to claim for redundancy. The said claim failed and same is hereby refused. On report of an asset on earned 2014 allowances, Exhibit DW1C, containing the end of service statement, clearly shows that the sum of 562,098 naira 63 kobo was deducted from the claimant's account, computed account as unremitted entitlement or allowances. The amount deducted is in respect of payment upfront made to the claim claimant. Exhibit CW1D and exhibit and evidence of the parties before the court clearly shows that claimant resigned his employment with the defendant based on advice of the defendant, and he did so to escape sanction as state. It's clear that the claimant resigned his appointment based on advice of the defendant. But this goes to show that though the claimant has stated that he decided to voluntarily resign, the resignation is in actual sense was not voluntary. Therefore, the defendant, who is mastermind of the claimant's resignation, is stopped from deduction of the unremitted allowances. This is because it is the defendant that This goes to show that though the claimant has stated voluntarily, but the resignation was not voluntarily, as it was foisted on him. In the circumstances, the deduction of earned allowances cannot be allowed to stand. This is because it is the defendant that made the claimant to resign his appointment. The claimant is entitled to refund of the deductions of an earned allowances made from the claimant's end of service entitlement. On long service, Exhibit DWC clearly shows that the long service has been computed and included in the end of service as per Exhibit DWC. The claimant having not established how he was short-charged for the long service, it cannot be granted. The claimant would have succeeded on this if he had tendered in evidence, document, or instrument that grant such an entitlement to the claimant. The failure to adduce the conditions of service has clearly affected this item of the component of the claim of the claimant. The claimant has also claimed 28% interest on all the items constituting the particulars of his claim, as shown in paragraph 20 of the amended statement of facts. The only evidence of interest adduced by the claimant is his own evidence and nothing more. The reason for being that the interest rate is fixed by the Apex Court, by the Apex Bank in Nigeria. The claimant ought to have adduced documentary evidence of the interest rate or call on experts in that field to testify. I am not convinced of the interest rate being claimed by the claimant. The claimant has submitted that the answer given by the DW1 under cross-examination is the effect that he does not know the interest rate has proved his claim for interest. This assumption is wrong on part of the claimant, as the burden is still on him to prove his own assertion and not rely on weaknesses of the opponent, which he has failed to do. In the circumstances, the interest claim on items constituting the claims are hereby rejected. From all I have been saying above, the claimant has proved part of his claim and is entitled to the claim that was proved. The claimant having admitted receiving the sum of 1,388,028 naira 50 kobo from the defendant as his entitlement. This amount will be deducted from the total amount proved, and the balance will be what the claimant will be entitled to as his terminal balance of his terminal benefit and other entitlement. In view of this finding, the claimant is entitled to the following proved claims. The sum of 1,693,492 naira 25 kobo, unauthorized deduction to offset bad loan granted. The claimant is also entitled to the sum of 783,278 naira 85 kobo, being claimant's monetized annual leave. The claimant is also entitled to refund of an earned 2014 allowances in the sum of 562,098 naira 63 kobo deducted from terminal benefit. The claimant is entitled to be issued with certificate of shares of the shares for the sum deducted from his account for the sum deducted to buy the shares from his account, or refund of the sum of 191,083 naira 54 kobo deducted from the claimant's account for repayment of the loan. The claimant is entitled to the sum of 3 million from the totality of the entitlement of the claimant now will be 3,088,809 naira 73 kobo. If the sum of 1,388,000 is deducted from this amount, then the balance will be 1,650,780 naira 23 kobo. Then the share certificate for the sum of 191 naira 50 kobo. For avoidance of doubt, the orders of the court as per the claim of the claimant, part of the claim succeeded is as follows. The claimant is entitled to certificate of shares paid for refund of the money deducted for the shares. The claimant is hereby ordered to issue claimant with certificate of allotment of the number of shares that the payment could have purchased, the payment deducted could have purchased, or in the alternative, refund to the claimant the sum of 1,091 naira 83 kobo 54 kobo being money deducted from his account for share purchase. 3. The claimant is entitled to the sum of 1,650,780.23 kobo as balance of his terminal benefit and other entitlement after deduction of the amount he has been paid from the amount he is entitled to. The claimant is hereby ordered to pay the sum of 1,650,780.23 kobo as balance of terminal benefit and other entitlement to the claimant. The claimant is also entitled to post assess at the sum of 500,000 naira. All monetary aspects of this judgment must be settled within 30 days from the date of this judgment, failing which 10% interest shall apply to the judgment sum until liquidated. Judgment is entered accordingly. On the claim,
My Lord, with profound respect and humility to your Lordship, I am J. Olu Adebambo. J. Olu Adebambo. I humbly announce appearance for the claimant. My Lord, is my Lord with me? J. Olu Adebambo is the name. My humble appearance for the claimant. My Lord, we want to appreciate the court for a well-considered judgment. We want to appreciate the industry of my Lord. We have learned a lot from this. Thank you very much, my Lord. We are most grateful, my Lord.
Yes. Is the defendant counsel online? Mr. Ikpebu.
May it please, my Lord?
Yes. You should.
My Lord, I apologize. Yeah, my Lord, I apologize. My network is having a problem. My video is not coming out.
Okay.
I'm very sorry, my Lord. May I humbly announce appearance for the defendant?
Okay.
Yes, my Lord. My Lord, I have also listened to the judgment, and I want to appreciate the court for a well-considered judgment. We are grateful.
You're welcome. The hard copy will be sent.
Thank you, my Lord.
It will be sent to you.
Well, as court pleases, my Lord, so you should contact the registry.
As the court pleases.
Yes.
Okay. Thank you very much, my Lord.
You are welcome. Call the case. That case will sit down.
Number NICN 802-2016 between Comrade Bibenchi Resport.
It's all right. Yes, Mr. Egan.
Thank you, my Lord. We have relocated. I think.
Okay. So what is the?
Yes.
How far have you gone with the settlement?
Yes, I think we have reached at this time very advanced stage. We ought to have filed our terms. We have prepared and
okay.
We have prepared the terms. We are supposed to send a copy to Lagos,
okay,
where where the claimants are. So we will just ask for very short time. Unfortunately, we got this hearing, the hearing notice very late. This afternoon. This morning.
It means you are not checking. It means you are not checking your phone and your email. If you had been checking your email address and phone, you will see it in time. Be checking your email and
the defendant
the email
lawyer
you provided in your process.
Yes.
We use it in sending the hearing notice.
The fourth defendant lawyer had similar problem too. That's why he's not here.
Okay.
I had to send it.
Okay.
I had to forward the copy sent to us to him. So it was too late,
right.
and I think
I will talk to the IT people so that they can make amend.
We will do so, sir. Very short date, very short date. I think we'll do.
How short? How short do you want? How short?
If we get, we're 2 weeks within the month, within 3 weeks month, within March.
Okay.
If we get a date within March.
Let me have your diary. Yeah, I will give you first week of April. Is first week of April okay?
First week.
Mr. Egan.
Sir, we're checking my diary, sir. First week of April.
Can you, what of,
if we take
when is Easter? Okay. Okay, can you come on 7th of April? April 7th. April 7th.
April 7th, I am in Jos. April 7th is not convenient, sir. We did in March. Maybe the last week of March.
My lord, if we can be accommodated by in the last week of March, my lord.
Last week of March, sir.
Okay. Can you come 31st? 31st of March. March 31st.
March 31st.
March 31.
It's convenient, very convenient, sir. It's convenient.
Okay.
Thank
This
you
case
so
is
much, sir.
adjourned to 31st day of March 2022 for report for further report of settlement. For further report of settlement or adoption of or adoption of terms of settlement.
As the court pleases.
Yes.
We are very grateful, sir.
You are welcome. You are welcome.
Okay. Thank you, my lord.
So you are welcome. Call the next case, registrar. Call the next case.
Number
Mr. Aga, you are free to go to terminate your appearance.
Thank you, sir.
Okay. 331-2017 between Austin Okuruban Fair and Economics and Financial Crime Commission, EFCC, and others. My lord, parties are absent.
So, congratulations, gentlemen.
Parties absent.
Yes, my lord.
And no legal representation. This case is for judgment. The judgment is ready. It goes like this. On the 14th day of November 2017, the claimant in this case took out a general form of complaint against the defendant. However, following striking out of the name of second defendant, The claimant amended its complaint and its accompanying processes to reflect the new position of the parties in the matter. The claimant herein by his amended complaint and statement of facts sought for the reliefs stated here under as follows. 1. A declaration that the purported letter of termination of my appointment by the defendant is wrongful, illegal, unlawful, unconscionable, unconstitutional, null and void, and of no effect whatsoever. 2. An order of this honorable court directing the defendant to immediately withdraw the letter of termination issued by the defendant against the claimant and reinstate him back to the position he would have been but for the wrongful termination. 3. An order of this honorable court directing the defendant to pay all the arrears of salaries and allowances from November 2015 date owed to the claimant by the defendant taking into promotions of his colleague in the alternative payment of compensation of the sum of 25,570,000 naira only. Upon being served with the originating process, the defendant filed a statement of defense and incorporated therein a counterclaim. The counterclaim prays for a declaration that the letter of notification of termination of appointment of the claimant dated 6 August 2015 is lawful and legal in line with the order of public service rules. 2. A declaration that the action of the defendant in terminating the appointment of the claimant upon failing promotion examination on 3 consecutive times as lawful and legal. A declaration that the claimant is indebted to the defendant to the tune of 405,028 naira 7 kobo. The defendant to pay the total sum of 405 naira 28 naira 7 kobo being salaries and entitlement paid to him after period of termination of his appointment. 4. A declaration that the claimant paid to the defendant the total sum of 405,028 naira 7 kobo being salaries and entitlement paid to him after period of termination of his appointment. 5. Cost of this case. At the hearing of the case, claimant testified in proof of his case as CW1. He tendered documents in evidence as Exhibit A to G. Witness was cross-examined by counsel for the defendant thereafter he was discharged. During examination in chief of CW1, the claimant adopted his witness statement on oath of 10th of October 2018 and relied on all the paragraphs of the paragraphs and pleaded 7 exhibit and asked the court to use it as his evidence. The defendant on his part called one Mr. Farida Sani of the Human Rights Resources Department of the defendant, who testified as DW1. DW1 tendered 8 documents in evidence, which were admitted and marked as Exhibit DWA to DWH. The witness was cross-examined by counsel for the claimant. Thereafter, DW1 was discharged. The claimant was employed by the defendant as a driver by letter of employment dated 26th of November 2008, Exhibit DA, on probation for 3 years. The appointment of the claimant was confirmed by letter dated 10th of December 2012. According to the claimant, his appointment is governed by the defendant staff regulations handbook and civil service rules and enabling law of Federal Republic of Nigeria, which is the operational guideline for every appointment and termination. The claimant stated that the termination of his employment did not follow due process as he was not queried, nor was he given opportunity to defend himself. The claimant's employment was terminated by letter dated 6th of August 2015 with effect from 3rd day of August 2015. The claimant stated that he made effort through letters he wrote to the defendant and the one written by his counsel to the defendant to rescind its decision but to no avail. The claimant further about that his appointment is for life, and at the time of his appointment he was just 20 years of age and have some much more years to serve. The claimant stated that all effort to secure another job was to no avail due to termination of his employment. During cross-examination, the submissions of the case of the defendant as per pleading before the court is that claimant was employed by the defendant as a driver and his appointment was confirmed in 2009. The claimant's appointment was terminated by letter dated 6th day of August 2015 on the ground of health and for failure to pass junior staff promotion exam on 3 occasions. The submissions of the defendant formulated one issue for determination of this suit, namely whether, in the light of the facts, evidence, and circumstances of this case, the defendant rightly terminated the appointment of the claimant. Argument on these issues has been captured in the body of judgment. I will skip reading the submissions. The claimant, on his part, also formulated 2 issues for determination. 1, whether or not termination of claimant appointment by the defendant was lawful. 2, whether or not evidence before the court and surrounding circumstances of this case, the claimant is entitled to relief sought in this claim. The argument on the 2 issues have been captured in the body of the judgment. I shall skip reading the submissions. I now proceed to the court decision. I have carefully considered all the processes filed by the parties, the evidence laid in the course of trial, as well as oral written submissions of counsel for both parties. The facts in this case are straightforward without complexity. The claimant was employed by the defendant by letter dated 26th day of November 2008 as a driver on 3 years probation. At the end of the probationary period, upon satisfying the requirement for confirmation, the claimant employment with the defendant was by letter dated 10th day of December 2012 have his employment confirmed. It is also evidence that in 2012 the claimant had swollen leg, foot, and was taken to National Hospital for treatment in Abuja. However, the claimant, after spending few days at the hospital without being formally discharged, left the hospital to seek alternative means of treatment. After spending 3 months, the claimant reported for duty. The claimant also in December 2012 reported that he was involved in a motor accident and broke his leg. While the letter dated 6th day of August 2015, the claimant's employment with the defendant was terminated with effect from 3rd of August 2015. The claimant wrote a letter of appeal to the defendant to reverse the termination of his employment without success. The claimant also resorted to Public Complaint Commission and Legal Aid Council, where a lawyer was assigned to take up his matter. They also wrote where the council wrote to the defendant and still they said the man was ignored. From the pleading and evidence before the court, the claimant is contesting validity of termination of his employment by the defendant due to lack of due process. The claimant has stated that he was neither paid nor being given opportunity to defend himself of any allegation of wrongdoing. The defendant on his part is insisting that the employment of the claimant was properly terminated in line with Public Service Rules 2008 and the defendant's staff conditions of service. In dismissal of or termination contract service or employment, it is fundamental to find out the status of employee and his contract of service. This is done by under consideration by the court. The claimant has pleaded as per paragraph 1 and 3 of the amended statement of fact that the claimant was employed by the defendant as a driver on salary grade level 4. The condition of service governing employment of the claimant are as contained in the letter of employment dated 26th day of 11/2008 and staff regulation handbook of the dependent and public service rule. I have studied the letter of employment exhibit A. It is patently clear from the letter as the staff condition of service the dependent tendered and admitted in evidence as exhibit G. It is to be noted that the condition of service as contained in exhibit G were made pursuant to section 9 subsection 1 and 2 of the Economic and Financial Crime Commission. The provisions read as follows. Section 9(1). The claimant in this case was employed by the defendant apparently in exercise of powers conferred on the defendant under Section 8 subsection 3 of Economic and Financial Crime Commission, and the regulation governing the employment of the claimant was made pursuant to Section 9(1) of the Economic and Financial Crime Act. In the instant case, the defendant has profusely argued that the claimant's employment has no statutory playbook, in that it is a contract of master and servant relationship which can be terminated for good or bad reason. The question whether contract of employment enjoys statutory playbook goes beyond question of fact alone. It is issue of law as well. In his pleading, the claimant has about facts as his employment and the condition of service. There is no dispute that the defendant in this suit is a creation of statute. However, that alone cannot close the employee with statutory playbook. The law is right that it is the function of court to come to conclusion whether the employment of the claimant has statutory playbook. After considering all the authorities referred to and the pleadings of the parties, I came to the conclusion that the contract of employment of the claimant has statutory playbook, as it was made pursuant to the provisions of the Economics and Financial Crime Commission Act, which also in Section 9 imbued the defendant with power to make regulation, which it has made as shown in Exhibit G. Therefore, the claimant's contract of service has statutory playbook. The term statutory playbook simply means covered by statute. Thus, an employment will be taken as enjoys statutory playbook when it is covered by or governed by statutory provision in any material particular as to appointment, employee, termination or dismissal, and other sundry conditions. See Idigbe versus Osun State College of Education. The employment of claimant having been made pursuant to the exercise of the power conferred on it by the Act establishing it, it is one that has statutory backing, thereby elevating it above ordinary master and servant. Having found claimant's employment to be well laced with statutory playbook, for the defendant to discipline the claimant, they must do so in compliance with the laid down procedure for removal of the claimant as stipulated in the letter of appointment Exhibit A and staff regulation Exhibit G, which must be in compliance with. It is only when the action of the defendant is carried out in compliance with the conditions of service that the action can be sanctioned and approved by the court. The law is settled that the only way to terminate a contract of service with statutory playbook is to adhere strictly to the procedure laid down for its termination. See the case of Bamboy versus University of Ilorin. See also the case of Olatunboso versus NISA. The letter of termination of employment of the claimant, Exhibit C, is clear and unambiguous, leaving no one in doubt as its intent that it is to say termination of claimant's employment retrospectively with effect from 3rd of August 2015 on the ground that the claimant's service is no longer required. In a contract of employment with statutory playbook, the procedure for employment and disposal and discipline, including termination of an employee, are clearly spelled out. The settled position of the law is that employment is that it is terminated in the way and manner prescribed by the relevant statute. That position follows from a general principles of statute which direct that a certain procedure must be followed. In case of determining any other manner of termination, inconsistent therefore will be null and void. The defendant has averred and insisted in the final written address that the appointment of the claimant was terminated pursuant to Rule 02086 when he could not pass the exam for 3 consecutive times. Misconduct, which is the opinion, does not warrant summary dismissal. It is the submissions of counsel that inefficiency and poor performance are grounds for termination of appointment, and claimant exhibit this when he absconded from work. The provisions of Chapter 8 of the Staff Regulation has made ample provision in Exhibit G on procedure to be followed to terminate employment of claimant. See Section 38 of Exhibit G. The claimant has denied being issued with query or appearing before any disciplinary committee. The claim that the claimant is guilty the claimant has denied being issued with query or appearing before disciplinary committee. The claimant has submitted that he was not given opportunity to defend himself before any committee or any committee was set up. The claim that claimant is guilty of infraction of Section 14 of the Economic and Financial Crime Act amount to claim for commission of crime. The claimant having denied appearing before any disciplinary committee, the onus is on the defendant to prove that positive allegation, or there is nothing before me to show that or prove that the claimant appeared before the disciplinary committee. The law is right that he who asserts must prove. See sections 131 and 32 of the Evidence Act. In the circumstances and in the absence of the committee's report or minute of proceedings showing the composition of the members of the committee, I find that no committee was set up to try the claimant, and that the claimant never appeared before any committee. On the issue of failing exam for 3 consecutive exams, the rule is relied The rule requires assessing the claimant on the job performance, but there was no such assessment tendered before the court, which was carried out by the defendant. In view of this above finding, the claimant's employment was done in contravention of the staff regulations on termination, Exhibit G. It is also to be noted that the defendant in Exhibit C letter of termination never stated grounds for the termination. Never mentioned failing of exam as one of the grounds for termination. The failure to issue query or invite the claimant to appear before the disciplinary committee to defend himself means that the claimant was denied fair hearing. Therefore, I declare the termination null and void. The case of the defendant was made worse with the date of termination being made retrospectively. The law is right. Termination can only be with immediate effect after or the case of the defendant was made worse with the date of termination being made to take retrospective effect. The law is right. Termination can only be made with immediate effect or made to take effect in future. The Supreme Court confirmed this position in the case of Underwater Engineering Company Limited versus Dubipem, reported in 1999, 6 Nigerian Nuclear Report, Part 400, page 156. Where it was reiterated that termination or dismissal cannot be made retrospectively. The very fact that dismissal cannot be retrospective presupposes that some kind of notice must be given if the dismissal is to be effective. The letter of claimant's employment, Exhibit A, clearly provides that where when an employment has been confirmed, it can only be terminated upon giving 2 months notice or payment in lieu of notice. There is no evidence before me to show compliance with these provisions of the regulation or conditions of service. In view of my finding that termination did not follow due process, the termination is hereby nullifies. The letter of termination is hereby set aside. The defendant is hereby ordered to reinstate the claimant back to his job with immediate effect. The decision on counterclaim. I now turn to the counterclaim. The reliefs being sought have been reproduced in the earlier part of this judgment. Therefore, there is no need to reproduce them again here. The counterclaim stands on its own, independent of the main claim. It is a separate action. The relief sought a declaration. The law is settled that for a party to be entitled to declaration, he must rely on the strength of his case and not on the weakness of the witnesses. The party seeking declaration must strictly satisfy the code of his entitlement to the same claim. He succeed or fail on the strength of his case. In the case at hand, the defendant is seeking declaration for declaration that the letter of notification of termination of appointment dated 6 August is lawful and legal in line with order of the public service rule, and declaration that the action of the defendant in terminating the appointment of the defendant upon failing promotion exam on 3-time attempt on the same grade level is lawful and legal. The defendant is seeking order for refund of salaries paid to the claimant. I have in this judgment found that the claimant's termination of employment did not follow due process, as the said termination was done in contravention of the conditions of service. In the circumstances as found the defendant counterclaim, I found that the defendant counterclaim failed. Defendant woefully failed to prove his entitlement to the relief sought in the counterclaim. Therefore, the claim failed and same is hereby refused. The case of the defendant was made worse due to lack of pleadings in support of the counterclaim. In the circumstances, the court has no foundation. The counterclaim has no foundation has no foundation to stand. It is bound to fail, and same is hereby dismissed. On the whole, the claimant succeed on his claim and the counterclaim woefully fail. Same is hereby dismissed. For avoidance of doubt, the orders of the court are as follows. 1. The letter of termination of appointment Exhibit C is hereby declared null and void and of no effect whatsoever. The defendant is hereby ordered to immediately withdraw the letter of termination of appointment issued to the defendant and reinsert him back to his position. The defendant is hereby also ordered to pay all arrears of salaries of the claimant from November 2015 to date and subsequently till the claimant is properly disengaged from service of the defendant. Judgment is entered accordingly. Judgment is entered accordingly. Thank you. The administrator, the virtual sitting has come to an end. You can discontinue with the sitting.